These are the three biggest mistakes people make when they're writing a will. I'm Taylor Kaspar, a estate planning attorney, and I help people make estate plans that actually work as intended when they pass away. So these are the three biggest mistakes that people make when they're writing their wills. Number one, they pick horrible personal representatives. A lot of times people choose people as personal representatives who are much older than them, like parents or aunts, uncles, etc. And the personal representatives are too old, and the likelihood that they either die before the person making the will or become incapacitated before the person making the will dies is high. So that makes them not a great personal representative, or people don't choose successor personal representatives to back up anyone who has died or become incapacitated prior to the person making the will dying or passing away, right? Other problems that people have when choosing personal representatives, they choose family members out of obligation, and those people are bad with money, they're poor with follow through, or they're not going to be equipped to take a will through the court process after the person making the will dies and passes away. Number two mistake people make when they are writing a will is that they make the administration way too hard for their personal representatives. Estate administration, probate doesn't have to be a horrible, terrible thing, although sometimes it can be. And people miss really important clauses when they're drafting wills that make the administration too difficult. They fail to specify that their personal representative doesn't need to pay a bond. And so then their personal representative is on the hook for thousands of dollars to a bond company in order to administer and distribute the will. A lot of times people fail to specify that the personal representative would be allowed to have an informal proceeding, which would just be a phone call with the courts. And instead, they end up in a court hearing, filing all this paperwork and doing all this extra stuff that was not necessary at all in order to administer this will. The third mistake that people make when they're drafting the will is that they don't properly execute the will that they've drafted. The state of Minnesota does not recognize holographic wills. That's wills you write yourself on a piece of paper and date and sign. And then the state of Minnesota does not recognize e-wills, so like DocuSign, and they don't recognize remote witnesses. So people who are quote unquote witnesses who aren't actually there with you. A lot of people don't know these rules. They don't know that there's a certain way that you have to execute your will. You have to sign it in front of two witnesses who are there with you in wet ink in order for it to be valid. And a lot of people fail to do that. They print something out and sign it. They write something themselves on a bar napkin and sign it, and they think they've got a will, and that is just not true. And so that's one of the biggest mistakes people make when they're writing a will. If you found this content useful to you and you want to know more about this, make sure you like this video and subscribe to this channel so that you can keep getting this information coming to you on a regular basis. And then also, make sure you follow the link below if you want to know more about how to get a will and get it done right so we can help you out.